Yes, Mr. Malik.
Now, my lord, at 200, the submission for your lordship kind consideration is this, my lord, after whatever little bifurcation of various provisions which are made in the scheme of Article 200. The submission is, my lord, at the original consideration on the first presentation of the bill. It can't be said, my lord, under the constitutional scheme that the governor has no jurisdiction at all to withhold the bill, which your lordships have interpreted to mean that it would fall. That is only with the second presentation when the route followed is of the proviso. If, my lord, the constitutional provision of 200 is to be read in the manner as it is being presented, then it would necessarily, inevitably result in deletion of option 2 at the original stage itself. And that would, my lord, with utmost respect, would constitute rewriting of the constitutional provision. Let me put it in the other way. The constitution makers had always thought it fit to provide for that eventuality that a situation might arise where at the first stage of original consideration on the first presentation, the governor takes his discretionary decision that it is not to be returned, it is not to be granted assent, and the assent has to be withheld. Because any other opinion, my lord, by your lordships, would necessarily render the second option at the original stage of consideration as otious and non-existent. And, my lord, with regard to two other arguments which are, my lord, being canvassed and are being considered once again at our request in the opinion, my lord, by the Honorable President, about the judicial review and providing a timeline, etc., my lord, your lordships are well aware of the distinction between Article 74 at one end and Article 163. Just have a look at that, my lord.
That has been already argued.
I'm not.
By the learned attorney, it has been read and reread.
I'm only flagging.
We have to tell the same thing which we told to Mr. Paul, that merely because the 5 lawyers repeat the argument doesn't make it strong.
My lord, the only submission was that 74, which is the provision, my lord, it does not having the provision parameter to Article 163(2).
So that has been already argued that
That's all, my lord.
Under 74 or after the advice is sought by the president, whatever opinion is given by the Council of Ministers, that is binding on the president. But that is not so insofar as governor under 163 is concerned.
Now, my lord, just come only as a matter of example, just note a few provisions, my lord, only one line each. Kindly come to 197.2 on the points, my lord, which your lordships have already considered. I'm only giving the number and reading one line, my lord, that wherever the timeline was to be prescribed for doing.
The learned solicitor has given the entire chart.
My lord, I just wish to read, my lord, that in the money bill, etc., my lord, if your lordship may kindly see 109.
No, the learned solicitor has given a chart showing the provisions wherever the timelines are provided, wherever the Constitution desired that for a particular theme, particular timeline has been provided, it is so specifically provided in
and also, my lord, for the deemed assent, also, my lord, wherever the provision had, where the constitutional scheme had required, it is provided. No, my lord, I'll not bother your lordship.
Yes.
Now, kindly.
Anything new, Mr. Malik is saying?
My lord, your lordship may kindly.
There is nothing new, but then everybody has to show his presence. That you have already shown your presence.
I'll just run through, my lord, only those judgments which I have not shown. I'm not reading it. Only on the proposition, my lord, I'll just show it to your lordship. Just the written submission which has been made available on my behalf, my lord, starts from page 536. My lord, this hard copy is available to your lordships, my lord.
Rajasthan, right?
Yes, my lord. 1.3.
Where you want us to take? 150, 530?
536. I'll just run through it and, my lord, I'll conclude, my lord, so that others are able to finish within the time granted by your lordships, my lord. My lord, with regard to 145.3 and 143, my lord, one submission why the word minimum has been provided. My lord, there are two routes, my lord, for your lordships under the constitutional scheme. My lord, my submission was that 145, 145.3 and 143, my lord, your lordship, sir, the constitution scheme provide at least two routes, my lord, there may be more, at least two routes, my lord, for correcting a view, if your lordship, whenever your lordship so desire. One is, my lord, your lordship referring it to a larger bench. And other is, my lord, 143, the honorable president coming forward and asking for your lordship's opinion. Why I'm explaining is that why minimum of 5 under 145.3. Now, my lord, supposing the further, my lord, the opinion is also permissible and legitimate and entirely constitutional, that step to seek an opinion, even when there exists a judgment of your lordships, more than one, and there is any consistency which needed to be obtained because of some ambiguity or for some change of circumstance or by passage of time. And secondly, my lord, there is no decision at all by your lordships. Both the situation 143 would be maintainable, legitimate and constitutional. My lord, but wherever supposing, my lord, and I'm going to give your lordships in my note, a situation which had arisen, where, my lord, the not reference, but when the reference was made by your lordship to a larger bench, it was only because a scheme which is framed by this honorable court by a 5 judges constitution bench judgment is reconsidered by 11 judge bench judgment, and where it is held that the scheme framed by your lordship, which is only traceable to Article 142, this honorable court, 11 judges bench, my lord, in that Unni Kishan TMA Pai, has held that not only the earlier view is to be overruled, but your lordship went to the extent of saying that the earlier review was unconstitutional. I'll show that only in one line. Now, my lord, therefore, when this 145.3 says minimum of 5, a situation may arise where the existing judgment is of a particular number of honorable judges, which may be 5, and your lordships want to achieve a consistency, clarity, and authoritativeness for the purpose of implementing 141 of the Constitution or 144. Your lordships can, the reference can be to more than 5 judges under Article 143. My lord, there's nothing new. And, my lord, out of the references where the list has been given, if your lordship may kindly see, there are 2 references in para 18 of my written note, my lord, 547. At least 2 references are there, which is by, my lord, 7 honorable judges under Article 145.3. Now, my lord, if your lordship may kindly come to third part of the submission at page 550. Only, my lord, a couple of judgments which have not been shown, which I am not reading. The relevant portions have been reproduced, my lord, on the point that it is a legislative act under 200 and it is a component and part of the legislative process. And, my lord, if your lordship may kindly come to para 30, which is a constitution bench judgment, my lord, in Union of India versus Valluri. Para 30 at page 551, my lord. The constitution bench of your lordships. And kindly come to the bold portion at 552.
His judgment has also been cited twice
Cited
by the learned solicitor as well as Mr. Kaul.
Well, the portion which I'm only one line which I wish to read is in that bold portion.
Yeah.
And I would stand corrected, my lord, if this is because my presence told me, my lord, that perhaps this portion was not read.
Page 552.
Because
Right.
the learned solicitor general also had, my lord, set up that few portions of some judgment was skipped, my lord. I'm only saying that this one line, if your lordship may kindly see the last line of the book.
Learned solicitor would not skip anything.
No,
That you can be sure.
Actually, learned solicitor, took all of you by a right. He said, yeah, I'm leaving certain points for my friends to argue. He argued everything.
And, my lord, that right most of the time.
It was your thing to check the solicitor from arguing all those points which he had allotted to all of you.
My lord, that ride is all, most of the time
Yes.
is very mysterious. My
Ah.
lord. Kindly see the last line of the bold portion.
Yes.
The only other legislative function of governor is that of promulgating ordinance. And this was with reference to the Act of Assent. So Act of Assent is legislative and the other act is to promulgate ordinance where it has been read, my lord. And if your lordship now kindly come to page 554. My lord, where your lordship judgments with regard to grant of approval for the rules, my lord, which your lordship frame either for the under Article 129 for the functioning and my lord, the dispersal of various emoluments to the employees and of the High Court, where your lordships have held, my lord, that even if the government approval is not forthcoming, your lordship will refuse to issue any mandamus because that even to that subordinate legislation, the grant of assent is totally legislative. That, my lord, is quoted in para 48 at page 556. Para 48 at 556.
Yes.
It is contended by the learned Attorney General the functions of President of India approving for rules framed by the Honorable Chief Justice relating to salaries, etc., is analogous to the President of India giving assent to a bill. It is difficult to accept the contention that the functions of President approving the rule is analogous to giving assent to a bill. The rules framed by the Chief Justice of India, though it's a piece of subordinate legislation, it is not a full-fledged legislative act requiring assent of the President of India. Then, my lord, similar thing your lordships have laid down.
How is this relevant?
My lord, the assent here, even under 200, is a full-fledged legislative act, which, my lord, cannot be conditioned with any timeline. And, my lord, it can never be.
But how does this observations are of
Because, my lord, the deemed assent has been read, my lord, in the reference which your lordships are considering. It's only from that perspective, my lord, it is being
We
placed.
will appreciate only relevant is pointed out because otherwise it unnecessarily increases our homework.
No, my lord, that's for that the respectful submission. Maybe I'm wrong in my understanding, my lord, but the submission is this, that if grant of assent, my lord, which is in any case being a governor, being a component of legislative process, it is essential legislative function. Then grant of assent is also essentially legislative, and therefore, my lord, there would not be any occasion for issuance of any mandamus or to laying down any timeline, or, my lord, in the present context, to
Yes,
hold.
yes, Mr. Vanendra Singh, this has been now.
So, your lordship may skip it, my lord. Kindly, my lord, now kindly see para 55 at the next page.
55. Yes.
In, my lord, page 558, there para 55 quoted. I'm not reading it. Your lordship may just make a note. Then, my lord, please see para 40. My lord, similar thing is said in Zaki. I'm not reading it in the next judgment. Para 40, my lord, of your lordship judgment. Page 560, my lord, the relevant portions have been highlighted. Then, my lord, the Constitution Bench in Allahabad High Court case, my lord, where the 30 days stipulation was read, which is already read, my lord, is mentioned in para 41. I am not reading it. Kindly, my lord, with judgment only 2-3 paragraph, which I wish to read it at page 563. Constitution Bench, my lord, on the issue of desirability and, my lord, imminent necessity in the process in the thought process, which should be a part of the constitution scheme, does not confer jurisdiction with the learned Solicitor General as submitted in detail. My lord, if your lordship may just permit me to read 4 or 5 paragraphs of Manohar Nula, my lord, which, my lord, the 17046 in the compilation which I have given,
You have expected.
which is, my lord, volume 43.
You already extracted paragraphs you want to read.
In Manoj Narula, I have not done that, my lord, because there are 4 or 5 paragraphs. I can leave it with the number, my lord. I just want to, my lord, your lordship's amicus submissions which were made and which then are dealt with and.
Paragraph 44 with the quoted part is from which judgment?
My lord, lordship may see it in para 64, but I wish to kindly come to the quoted portion itself. There was something more, so I said. if your
Something more
lordship-
is missed out.
Anyway, my lord, I'll read it from here. My lord, if your lordship may come to the judgment. Kindly come to, my lord, para number 38. 430, my lord, which is the printed 17079 in the judgment compilation. Para 38, my lord, I didn't reproduce it here. If your lordship may permit me to read it from here. Para 38 at 17079. This was, my lord, the necessity and desirability which was thought fit for introduction as a disqualification, my lord, in the Representation of People Act, my lord, which was under question, and your lordships considered the submission, my lord, para 38, your lordship may just make a note, the submission made by Mr. Prasaran, my lord, and in the last three lines, that if such a submission is to be introduced by interpretation, that it would be traveling beyond the jurisdiction. Thereafter, your lordship may kindly come to para 64 at page 17090. Your lordship may just make a note and then please come to 67. My lord, para 64, last three lines. In the absence of any constitutional prohibition or statutory embargo, such disqualification are considered opinion, cannot be read into Article 75(1) and Article 164(1). Last three lines of para 64. Kindly come to para 67. The question this is to be posed here is whether taking recourse. I'm sorry. Para 67. And this is, my lord, your lordship may just know, your lordships are aware of it. My lord, where under Article 74, 75, my lord, the submission was by interpretation, you read a further disqualification in the appointment of minister. Kindly see 67(4) line. The question that is posed is whether taking the course to the purpose of advancing constitutional culture, can a court read a disqualification to the already expressed disqualification provided under the Constitution 1951 Act? The answer has to be in the inevitable negative, for there are express provision stating the disqualification, and second, it would tantamount to crossing the boundaries of judicial review. Thereafter, one paragraph 98 at page 17100, para 98. My lord. And please see last four lines of para 98. The entire para, my lord, I wish to read, but your lordship may just permit me. The last 5 lines, the framers of the Constitution.
Yes.
The framers of the Constitution left many a thing unwritten by reposing immense trust in the Prime Minister. The scheme of the Constitution suggests that there has to be an emergence of constitutional governance, which would gradually grow to give rise to the constitutional, and so on. Then it is what then your lordship may just make a note of 99 and 100. Last 2 lines of 99. Last 2 lines of 99. We have already held that prohibition cannot be brought in within the province of advice, but indubitably the concept, especially the constitutional trust, can be allowed to be perceived in the acts of such advice. So, my lord, this honorable court left it and said that we would not have any jurisdiction under our judicial review, my lord, to lay down any further disqualification, which is specifically provided. Now, my lord, this is followed in a subsequent constitution bench judgment, my lord, at page 17133. Of the same volume, my lord, which is also mentioned in the note, 17133. On the similar lines, my lord, and I'm not reading it, it's also a constitution bench, my lord, which also was after Manoj Nurullah. Coming back to my note, my lord, which I have furnished, I was at page 563. At 571, my lord, the timeline can't be laid down under 200, my lord. I'm not reading it. It is mentioned at page 571. Then 574 onwards, my lord. 574 onwards. The 10th schedule direction which have been issued from time to time, my lord, on various occasions for laying down the timeline. At page 577, my lord, in Paddy Koshik Reddy, which is mentioned in para 57 of the note, the para 30 of the judgment is quoted, my lord. And kindly see first 5 lines of para 30 at page 577. It can thus be seen that this court in unequal terms has held that it was inappropriate to claim that the determinative jurisdiction of the speaker in the 10th schedule to the constitution was not a judicial power and was within the non-justiciable legislative area. This was rejected. Because the judicial review and justiciability norms and the standards, my lord, are different whenever it is a legislative function as compared to, my lord, the quasi-judicial functioning. With regard to 202, my lord, the overruling of the view, your lordships have already seen the learned solicitor has made submission, overruling a judgment and overruling a view. And, my lord, only 581, if your lordship may kindly see, these, my lord, in my respective submission are the 4 main areas, which, my lord, the existing in the second column, my lord, in that table, the existing views on that aspect with the relevant para numbers. In the second column, the aspect is in the first column. The second column is the existing views and the para numbers, my lord. And this is how, my lord, this has not been, my lord, in our respectful submission. First of all, it had deserved, my lord, as the learned Attorney General had made a submission in the Tamil Nadu case, that this case would require to be considered by a larger bench. My lord, at that juncture, it is my respectful submission, my lord, the submission which was made by the learned Attorney General in the facts of that case and the existing various differing views, or, my lord, a differing views to be taken, had deserved, my lord, with utmost respect, consideration for acceptance to refer the matter to the larger bench, because in a number of cases, I have cited the judgments, my lord, in your lordships in this written submission, where your lordships have said that it ought to have been referred to a larger bench at that very stage. Now, my lord, if your lordship may proceed further, 588. This submissions I have already made, my lord. They are put in my note in the form of table and the following paragraphs. Then, my lord, the relevant portions of Pavitra, which have already been ref, is only, my lord, mentioned in page, my lord, 592 onwards. And then your lordship may kindly come to page 601, which, my lord, the direction 142, my lord, if it is individual rights are being determined to do complete justice. To that extent, my lord, your lordships have said 142 would always be utilized. But, my lord, where it seeks to lay down something as a matter of policy of uniform application, which is law, then, my lord, your lordships have said that that may not be permissible. The first judgment, my lord, in para 96 at page 602, my lord, was the constitution bench of your lordship, my lord, where the former president of the Bar Council of India alone had met with the punishment here. And that, my lord, was considered by your lordship that that jurisdiction belonged to the Bar Council of India. And your lordship recalled that order, and, my lord, had referred the matter. In that context, my lord, the observations which have been made in para 97, quoted at 603, para 47 at page 97, and at page 603, my lord, page 602, in para 97, the constitution bench decision, my lord, relevant para 47 has been reproduced. And, my lord, if your lordship may kindly see at page 604, last 5 lines in that bold portion, my lord, on the top. To the extent that this court may, my lord, the 5th line from top and that bold portion, my lord, to the extent this court makes the statutory authorities and other organs of the state perform their duties in accordance with law, its role is unexceptionable. But it is not permissible for the court to take over the role of the statutory bodies or other organs of the state and perform their functions. Then, my lord, in judgment, my lord, in ONGC's case, which is para 19, in the bold portion, my lord, your lordships have held that wherever it is a part of a policy of legislation, your lordship will not exercise and decline to exercise in 142 and something more, my lord. With regard to timeline, my lord, the special laws laying down the outer limit for the courts to condone the delay, and, my lord, where the strict timelines are laid down. In a number of occasions, my lord, this court felt that perhaps this strict interpretation of such restricted timeline may not do justice. But your lordships have said we will not exercise our power under Article 142 because it is nothing but rewriting the provision of law itself. Then, my lord, if your lordship may kindly see para 103, Unni Krishnan, my lord, your lordship may recall, my lord, Mohini Jain. Mohini Jain, my lord, in 92, your lordships in the two-judge bench judgment had laid down that there is a fundamental right to education. You'll read it under Article 21. The constitutional provision of directive principle of Article 45 had permitted it only up to the age of 14 years. So, my lord, when this was done, this was considered. The Mohini Jain was considered, my lord, in Unni Krishnan, and your lordship said that this right is to be restricted only to 14, and then proceeded to frame a scheme by your lordships, my lord, to be adhered to and followed by converting it to as a conditions of eligibility for qualification and recognition, etc., as a statutory provision. And that, my lord, held to be, my lord, a statutory exercise to lay down the law, which was then considered by 11 judges in TMA by only two portions, my lord, para 45, which is reproduced at page 608. So a statutory, virtually scheme is laid down on your lordship judgment that 50% seats would be free, 35% would be for a particular amount, and 15 NRI, and this must be followed by everyone. This judgment is delivered in 1993. It held the field under Article 141 till 2002, when this 11 judges considered. In para 45, that view and scheme is overruled. And in para, my lord, in 161, that question number 9, which was framed, your lordship said that the framing of that scheme by the Supreme Court was unconstitutional. Now, my lord, supposing in 1993, my lord, I just make a humble submission for your lordship kind consideration, where after 1 decade, the scheme framed in the judgment of this honorable court, which is implemented as Article 141 by all high courts and by all the states, is then re-examined by 11 judges. And, my lord, your lordship says the scheme was unconstitutional. Please visualize the situation that a reference was preferred to be made by the honorable president in 1993 itself when the judgment came, because the judgment may be taking away rights of various parties. The reference would have been maintainable. And, my lord, this situation left a scheme to operate as Article 141 as lawmaking for 10 years, and which eventually your lordship laid down to be, my lord, as unconstitutional. Kindly come to the next page, my lord. 610. My lord, from 610 to, my lord, 625, the questions, my lord, which are the 4 aspects which I have, my lord, tabulated in the earlier part of the written submission, that on which the views are already existing even by larger benches, and the state of Tamil Nadu has taken a differing view, my lord, which would require this presidential, my lord, request to be considered. My lord, I have only given the relevant portions for your lordship's convenience here itself. And, my lord, at page 626, my lord, the reasoning is not appearing at page 626, which continuation of para 412 from 625 and 413, that why a particular situation in Sri Lanka is accepted and the position which is equivalent to our constitution and was prevalent in Canada is not accepted, my lord, or disregarded in, my lord, rendering the judgment in the Tamil Nadu case, my lord. So therefore, my lord, my respectful submission in support of the submission which I have already made, that, my lord, the reference would deserve to be considered and answered, my lord, in the light of the submission which you have respect to. I am deeply obliged, my lord, for your lord.
Only just, Lord, your lordships are right. Lord, I did say that we'll distribute. We discussed, my lord, but it was felt that this being a reference from the honorable president, it's better that the central government put forward its view in entirety. Others may supplement.
No, we understand everything.
Rather than state, one state saying something, another state often objecting to it, better the central government says on all points.
Yes, please. I've taken the clue from the court, what has fallen from the court, that learned Solicitor General has covered everything, but still I'll take only 5 minutes in the matter. Kindly take volume 1,
For whom?
2 states, that is state of Odisha and Uttar Pradesh. And the return notice on behalf of Odisha. It's a written note that is submitted on behalf of state of Odisha in volume 1, Roman 1.6. The light of the reference made by the Honorable President, actually, so far as these states are concerned, we have made 3 issues which fall for consideration. That is at page number 662. There is the first one is whether it would be permissible for the judiciary to impose a timeline or time limit for disposing of bills by the governor. 2, whether the failure to adhere to such timeline or time limit would ipso facto make the bill a legislation by deemed assent. Third one, whether the situation prior to or anterior to the assent would be justiciable. So I'll be focusing only on 3 issues with regard to in the context of all the reference made by the Honorable President. These issues will have to be considered by keeping in mind one of the key factors, that is the functional autonomy of the President and the Governor. The President and the Governors, they enjoy an absolute functional autonomy within their discretionary functions or within their spheres. To substantiate that, we have taken the shelter under 3 articles. That is, number 1 is Article 60 or 159 with reference to their oath, which categorically says the oath will be taken by the Honorable President and Honorable Governor to preserve, protect, and defend the Constitution. It is in contrast or with the all other constitutional functionaries in the 3rd schedule will be taking oath to defend the Constitution, whereas the absolute autonomy of the President and the Governor is one of the factors which is indicative from these 2 articles, 60 and 159. Then thereafter again, Article 200, where the discretion has been given to the President and the Governor, which is already argued by this one. This is the second factor. The third one is Article 361. From these 3 articles, it can be made out without any doubt that the President and the Governor have the absolute discretion in their functioning a stage prior to grant of assent. Now it is a functional autonomy of the President and the Governor. Now this is a situation where we are not examining the correctness of the decision taken by the President or the Governor. It is a stage prior to the grant of assent or the decision taken by the President or the Governor. In all earlier editions, whether it's a Quixote Holovan or all other constitutional judgments, the decision of the Governor, including in SR Bommai's case, that was the decision where the decision was examined in the context by analyzing it as a tribunal. Now we are examining the stage prior to the decision taken, yet to be taken by the governor by granting, not granting assent at the particular time, and thereby the court fixing a particular timeline. Yes, if the assent is not given within a particular time, what should happen, and whether the mandamus can be issued to the president or the governor. This is a stage prior to that. Now, this is yet the one more aspect is the word specifically expressed in Article 200, which is again as soon as possible, which is already argued by the others. Therefore, he has absolute discretion with reference to his functioning even under Article 200. Now, in support of this one, now I have quoted from SR Bommai's case at page number 667, two factors, that is from para 240, where they refer to Encyclopedia on American Judicial System by Justice Ramaswamy, which was a concurring judgment at page 240, para 240, which is available at page number 667. May I read that?
Yes.
The standard of assessing constitutionality must be the words of the Constitution, not what the judges would prefer the Constitution to mean. The constitutional supremacy necessarily assumes that the superior rule is what the Constitution says. It is not what the judges prefer it to be. So the absolute supremacy or the autonomy, what the governor, the president or the governor enjoys, that cannot be read into by saying something beyond what is specifically said in the Constitution, which is nothing but either reading down is not permissible or supplying casus omissus to the Constitution. It is not permissible with regard to the interpretation of the Constitution. That again kindly turn to para 238 of that SR Bommai's case at page number 667, I quoted. After about para 238, after about 5 lines, I put it in bold letters. But such an interpretation in our specific view is not permissible when we are called upon to interpret the organic constitution and working the political institutions created therein. When Parliament has had an opportunity to consider what exactly is going wrong with the political system designed by the Constitution, but took no steps to amend the Constitution in this behalf, it is a principle of legal policy that the law should be altered deliberately rather than casually by a side wind only, by a major and considered process. Then again further, in Quixote Holohan case, at page number 668 in para 17, I quoted, where the Quixote orders are, whether it's a permissible or not, that has been referred to in 5 judges bench of Quixote Holohan in para 110. Page para 110 of Quixote Holohan. Any of the limited scope of judicial review that is available on account of the finality clause in paragraph 6 and also having regard to the constitutional intendment, the status of the repository of the adjudicatory power, that's the speaker, chairman, judicial review cannot be available at a stage prior to the making of a decision by the speaker or chairman, and quiatimate action would not be permissible. So that exactly the situation where now here we are considering a stage prior to either grant of assent. In such a situation, even quiatimate order cannot be granted by even judicial reviews also may not be permissible at that stage because of the functional autonomy he has. Now to say that by supplying the casus omissus, again in para 11111 of the same judgment, Quixote Holohan, the second subpara, however, having regard to the constitutional schedule in the 10th schedule, judicial review should not cover any stage prior to the making of the decision by the speakers of the chairman. That is by assuming that he is the tribunal, by assuming that for the sake of argument. Having regard to the constitutional intent and the status of the repository of the adjudicatory power, no ultimate actions are permissible. The only exception for any interlocutory interference being a case of interlocutory disqualification or suspension, which may have grave, immediate, and irreversible repercussions and consequences. So this is not the situation, even as we are examining a stage prior to the grant of either assent or the function, which has absolute power or function to consider or to decide a particular case within his discretionary power. Now we can't equate it to the position of the tribunal with like the speaker's edition, which was a subject matter of review, or even 356, that was a post-decisional review of the order passed or the reference made by the Honorable Governor, that was under consideration. See, here the situation is a stage prior to that of, therefore there is even ultimate order or the judicial review of any of the action or justiciability, that is not at all permissible. And while interpreting the constitutional provision, especially Article 200, there is no question of supplying casus omissus. Casus omissus cannot be supplied at all to the interpretation of the constitutional provisions. Therefore, when the language is very clear, the articles are clear, we need not or we should not supply casus omissus to the provisions of the Constitution and say that, yes, because there is some kind of deficiency, there is some kind of some issue arises for consideration. Therefore, the judiciary steps in and issuing a direction that may not be permissible. Then the question may arise in certain situations where the wrong decisions are either not taken or something is happening. Then whether it would be the judiciary can step in. I can put it in the words of the Honorable Court itself, which I refer to in para 20 of the note at page number 669. That's the extract from the common cause case, last about 6 lines in page number 669. If the legislature, page number 669 of the note, if the legislature or the executive are not functioning properly, it is for the people to correct the defects by exercising their franchise properly in the next elections and voting for candidates who will fulfill their expectation or by other lawful means. Example, graceful demonstrations and agitation, but the remedy is not surely not by the judiciary in taking over the functions of the other organs. Yes. I'll read it again, the para, that's a para 40 at page number 669. The justification given for judicial activism is that the executive and the legislatures have failed in performing their functions. Even if this allegation is true, does it justify the judiciary in taking over the functions of the legislature or the executive? In our opinion, it does not. Firstly, because that would be an violation of the high constitutional principles of separation of powers between 3 organs of the state. And secondly, because the judiciary has neither the expertise nor the resource for this. If the legislature or the executive are not functioning properly, it is for the people to correct the defects by exercising their franchise properly in the next elections and voting for candidates who will fulfill their expectations or by other lawful means. Example, peaceful demonstrations and agitations. But the remedy is not surely not by the judiciary in taking over the functions of other organs. This is as has been put by the Honorable Court itself in the common cause case. So my submission would be, judiciary cannot be the pill for every disease. By assuming that there is some kind of defect or some kind of problem in the functioning of these 2 officers in some situations also, it may not be proper for the judiciary to step in and issue a direction which would be totally hit by the principles of separation of power, and that may not be permissible. Therefore, by keeping in mind 3 aspects, number 1, the functional autonomy of this one, the scope of interference by another organ in the such important or the discretionary function of the high constitutional functionaries, a pre-decisional judicial review or justiciability is not at all permissible. Therefore, to that extent, with reference to the 3 questions I have framed, kindly consider these 3 aspects and leave it. I'm grateful to you.
Everything has been submitted. I come. quite towards the very end, Malins. Malins, I have a note which I'll give, Malins, which sort of takes care of most of my submissions, which I want to. But I'll summarize it in 2 points, which I want to largely highlight. And Malins, both are one which has been
You are
dealt.
appealing for whom?
I'm sorry, Malins.
You are appealing for whom?
State of Goa, Malins. Malins, the rest of it is in the notes of submission. I'm not going over that. I've made extensive submissions on that. Malins, the 2 points which I want to submit is one on deemed assent, which has been addressed by Mr. Salve in extenso also. But my point on that is, and I'll summarize the point and then I'll quote from the judgments which I've extracted in my note. It is very clear in terms of the decisions of this court that the process, I'm not saying the governor is a part of the legislature. I am saying that the process of legislation.
Short part of the legislature.
Malas, I am not saying, Malas, I'm qualifying it. I'm taking it one step ahead. I am not saying that. I am saying that the process of legislation cannot be complete unless it receives the assent of the governor. So because the process cannot be completed, there is no question of deemed assent. Because no one but the governor, as specified in the constitution, can give that assent for the process of the legislation to be complete. The courts can, number one, the constitution does not envisage a concept of deemed assent. Number two, the judiciary cannot insert itself into a position whereby such deemed assent can be given at all. Malats, there are 2 judgments, Malats. One which has been quoted, Malats, but I have quoted that in my note, Malats. BP Singhal has been quoted. I'm just quoting that so it's easier. Malats, I have the, Malats will please come to page number 14, para 28, 8. Malats, I'll just read it out from that so it's easier.
BP Singhal.
BP Singhal, Malats, has been cited. The Constitution observed the role of the governor. In the case of BP Singhal, a Constitution bench observed the role of the governor as part of the legislature. Position of the governor under the Constitution. The governor constitutes an integral part of the legislature of the state. He is vested with the legislative power to promulgate ordinances of the legislature are not in session. The executive power of the state is vested in him, and every executive action of the government is taken in his name. He exercised the sovereign power to grant pardons, reprieves, respites, remissions, or punishment. He is vested with the power to summon each house of the legislature to prorogue either house or dissolve the legislative assembly. No bill passed by the houses of legislature can become law unless it is assented by him. He has to make a report when he finds a situation has arisen in the government of the state cannot be carried on in accordance with the Constitution. He thus occupies a high constitutional office. Similarly, Malats, I have another judgment called State of Kerala versus Mara Prem, which I don't think is part, which I have also quoted, which is at para 30. Malats, I'll just read that, quoting para 50. Broadly speaking, lawmaking is exclusively the function of the legislatures. The president and governor are part of the union or legislatures of the state. As far as the parliament is concerned, the legislative process is complete as soon as the procedure prescribed under 107 of the Constitution and connected provisions are followed, and the bill passed by both the houses of parliament has received assent of the president under Article 111. Similarly, a state legislation becomes an act as soon as a bill has been passed by the state legislature and it has received the assent of the governor in accordance with Article 200. I'm sorry, please. So the act of assent is integral to the completion of the process of legislation. There cannot be a deemed assent. The Constitution, number one, does not provide, unlike in many cases, Malats has in British constitutional law, where there's a possible of the second time it's passed, it is taken that the sovereign has given assent. There is no concept of deemed assent. And in the present case, The process is only complete if there is an assent of the governor.
But deeming is only a fiction.
I'm sorry.
That deeming is only a fiction. That something which does not happen in law, still it will be presumed that it has happened.
Well, there are a number. If the constitution provides a certain process to be followed, it has to be followed. And in this case, present case, well, it's deemed assent. The only sort of example which I can sort of see the discussion of deemed assent happens in the sovereign in British constitutional law. But there is no provision, there is no example whereby the courts can grant deemed assent in any constitutional law to my understanding of or my looking at. The second issue, Malats, I know that it has been placed MP Special Establishment Act. This is the second issue which I want to place. But para 12 of MP Special Establishment needs reading. It's an extensive paragraph where Mr. Sorabji's argument is quoted in relation to Shamsher Singh. But Malats, the most important part is towards the end of it, is Malats will come to my note at para 35.
Lord, at page 375 of my submissions, I have, Lord, given a chart of all provisions where the institution says that it would be deemed to have happened or not.
Put the charts, one chart, wherever timelines,
Timeline
wherever
is
the
prescribed.
constitution wanted to provide timelines,
My Lord,
those
sir.
provisions where timelines are provided, and wherever the constitution wanted a deeming provision to be there,
It is specifically there.
specifically mentioned.